better? Attorney Nicole Martucci from KSRP Law at 128 Dorrance Street here in Providence, Rhode Island. My firm represents a coalition of business owners and property owners in the city of Providence who vehemently oppose this project. My goal for being here tonight is to impress upon you the fact that an approval of the project and an approval of the petition as presented would in fact violate state law, and it would violate your own comprehensive plan. The petition seeks to create a new district, D600, that would just be for this property. And it requests a waiver of design standards that all other properties have to comply with, except for this property. That, in and of itself, is the definition of an illegal spot zone. The Zoning Enabling Act mandates that any enactment or amendment, which this would be, of a zoning ordinance must be compliant and consistent with the comprehensive plan. The Rhode Island Supreme Court has made it very clear that the comprehensive plan of the municipality is not some innocuous general statement that can just be tossed aside and ignored. It's a binding framework that a municipality must consider. In 2014, your city has spent a significant amount of time and resources to amend the comprehensive plan that was unanimously accepted. To allow the petition as presented to ignore that comprehensive plan and just build a tower that's 600 feet in the air would violate the Zoning Enabling Act. Your own Plan Commission has acknowledged that this project that's presented is a violation of the comprehensive plan. Sam Shaboon, who is a recognized zoning expert, has submitted a written report that significantly details all of the areas of the comprehensive plan that this project would violate. For example, the comprehensive plan calls for a gradual raise of heights of buildings. You don't have to be an engineer or a mathematician to acknowledge the fact that a 100 foot height and a 600 foot height is not a gradual increase. That's significant and destructive. If you want to talk page numbers, you can go to page 112 of the comprehensive plan, page 50 of the comprehensive plan, and go on and on, all the areas of the comprehensive plan that acknowledge that this particular property is in fact a D100 district, which says that you can only have a building of 100 feet, with some exceptions up to 130 feet, but certainly not 600 feet. And I want to make it very clear that it's well settled in this jurisdiction that the Rhode Island Supreme Court shall invalidate, not may invalidate, not might invalidate, but shall invalidate any enactment or amendment of a comprehensive plan that's in
30 seconds.
The Supreme Court will invalidate any change to a zoning ordinance that's inconsistent with the comprehensive plan, and we don't have to get that far. If you are consistent with the comprehensive plan as it's presented, there's no need to get to the level of the Rhode Island Supreme Court, but that's where this is going to go if this is approved as presented.